There is ongoing uncertainty about whether and to what extent agreements for third-party litigation funding can be subject to discovery. This is true in all kinds of litigation, but some recent decisions have reached opposite results in class actions. The difference ultimately arises from different views about whether the existence of a third-party funder is relevant to class certification issues. In one case, the defendants sought discovery about the relationship between the representative plaintiff, class counsel, and a third-party litigation funder. According to the defendants, such discovery was necessary to explore whether the funding arrangements could affect the strategic decisions they will make on behalf of the class, or could cause counsel's interests to differ from those of the putative class members they purport to represent. In addition, the defendants argued that the discovery would be necessary to determine whether there was a potential for conflicts between the representative plaintiff and the class over the costs associated with litigation funding. These arguments did not prevail, however. The district court declined to compel the production of funding documents. The court found that class counsel's representations about the adequacies of its resources were sufficient. Any questions about potential conflicts between the class and the representative plaintiffs was purely speculative. Another case arose from a fire on an offshore drilling rig off the coast of Nigeria. The plaintiff class was comprised of fishermen who alleged that their businesses and health were adversely affected by the fire. The defendant again argued that the disclosure of litigation funding agreements was necessary to determine the adequacy of class counsel's representation. Unlike the first case, however, the district court did permit discovery of the litigation funding arrangements. But there were unique factual circumstances in the second case. Most importantly, there were serious questions about the adequacy of class counsel, who was a sole practitioner with no formal office or support staff. Also, class counsel had missed deadlines due to a lack of resources. In addition, the confidentiality provision of the litigation funding agreement, which class counsel had quoted in a brief to the court, seemed to indicate that the agreement would be subject to discovery. These two cases demonstrate there is no single clear rule for determining the discoverability of third-party litigation agreements. In the ordinary course, there are strong reasons for prohibiting discovery. But when there are real questions about the adequacy of class counsel, and when litigation funding is a crucial factor in assuring such adequacy, discovery may be warranted. If you need help with litigation funding, call or email me today.